You have just spent 14 months overseas. 14 months in a place where the heat never lets up, where you sleep in shifts, where every single day you are doing a job that most people back home will never fully understand. You are not thinking about your lawn. You are not thinking about your gutters. You are not thinking about whether your mailbox looks fresh enough for the neighborhood association. You are thinking about getting home alive. And then the day finally comes. You land. You breathe American air. You hug your family. You drive down your street. You pull into your driveway. And on your front door, taped right there in plain sight, is a stack of notices. Not one, not two, 11. 11 official HOA violation notices, issued over the course of 5 months. For an overgrown lawn, peeling paint on the front trim, a cracked section of the driveway edge, a fence post that had apparently leaned 2 degrees to the left at some point during the winter, and at the bottom of the stack, a certified letter from the HOA board informing me that due to the abandoned and neglected appearance of my property, they had voted to place a lien on my home and were exploring legal action for ongoing and willful noncompliance. I stood on my front porch in my uniform, bag still on my shoulder, and I read that letter 3 times. Not because I did not understand it, because I wanted to make absolutely sure I understood every single word before I decided what to do next. This is that story. My name is Marcus, and before any of this happened, I was just a guy who owned a small house on a quiet cul-de-sac in a suburb outside of San Antonio, Texas. Bought it in 2018. 3 bedrooms, nice yard, good bones. I was proud of that house the way you are proud of something you worked hard to earn. I joined the Army at 19. By the time I bought that house, I had already done 1 deployment. I knew what it meant to leave for a long time. I had a plan for the house when I was gone. My neighbor Dale, a retired contractor in his 60s who lived 2 doors down, had agreed to keep an eye on things. Mow the lawn every couple of weeks. Make sure nothing looked catastrophically wrong from the outside. Nothing elaborate. Just enough to keep the place looking lived in. Dale was a good man. Solid. The kind of neighbor everyone should have. What I did not account for was Linda. Linda had moved into the neighborhood about 8 months before my deployment. Corner house, perfectly manicured lawn, flower beds with military precision, and I use that phrase now with a full appreciation of the irony. She had joined the HOA board within 60 days of moving in, which should have been a warning sign to everyone in that cul-de-sac, and was not taken seriously enough by any of us. I met her exactly once before I left. Brief introduction on the sidewalk. She asked if I were the owner of the Bay's house. I said yes. She said the trim color was not on the approved palette list, and I should check the HOA handbook. I smiled. I said I would take a look. I deployed 3 weeks later. Now here's what happened while I was gone. Dale did his job. He mowed the lawn. He picked up any mail that piled up. He checked on the property every 10 to 12 days just like we agreed. By any reasonable standard, the house looked fine. Not perfect. I was not there to do the small maintenance things that homeowners do constantly without thinking about them. But fine. Lived in. Normal. But Linda was not looking at my house with reasonable standards. Linda was looking at my house with a clipboard. The first violation notice was issued in month 2 of my deployment. Lawn height exceeding HOA maximum of 4 inches. Dale had mowed 10 days prior. Texas summer growth. He mowed again immediately when he saw the notice. The second notice came 3 weeks later. Visible weed growth in the front flower bed. The third notice, a small oil stain on the driveway near the garage door. Each notice came with a fine. $25 for the first, $50 for the second. The fines escalated with each subsequent notice following the HOA's penalty schedule. And here's the part that matters. Nobody contacted me. Not a single phone call to the number on file. Not a single email to the address in the HOA system. Not one attempt to reach the homeowner before the notices started stacking up. Because Linda, and I confirmed this later with 2 other board members who were genuinely uncomfortable with how this had unfolded, Linda had told the board that the house appeared to be abandoned, that the owner had clearly moved out, that continued leniency was unfair to the neighbors who maintained their properties properly. She did not mention that she knew I was in the military. She did not mention that she had been informed by Dale, who had told her directly, face-to-face, in the driveway, in month 3, that the homeowner was deployed overseas. She left that part out entirely. The board, trusting their newest, most enthusiastic member, followed her recommendation. The notices kept coming. The fines kept accumulating. The lien was approved at a board meeting in month 5. $6,400 in fines, penalties, and administrative fees. On a house whose owner was serving overseas and had no idea any of this was happening. I read that certified letter one more time on my porch, folded it carefully, put it back in the envelope, and I thought, very calmly, very clearly. When we left off, I was standing on my front porch in my uniform, reading a letter telling me that my HOA had placed a $6,000 lien on my house while I was deployed overseas. And I want to tell you something right now that is important. My first instinct was anger, real anger, the kind that sits in your chest and makes everything feel sharp and bright at the same time. 14 months of doing one of the hardest jobs on earth, and I came home to this. To fines for a slightly overgrown lawn. To a lien on a house I had worked years to be able to own. But I had been in the army long enough to know one thing very clearly. Anger is a fuel, not a strategy. So I did not call the HOA that night. I did not go knock on Linda's door. I did not post anything on the neighborhood Facebook group. I unpacked my bag. I ate a home-cooked meal for the first time in over a year. I slept in my own bed. And the next morning I called a lawyer. His name was Robert Chen. He specialized in military law and housing rights. My army buddy Darius had used him 2 years earlier for a landlord dispute during a deployment and described him as a kind of attorney who makes the other side realize very quickly that they have made a serious mistake. I drove to his office with a full stack of notices, the certified lien letter, my deployment orders, and every piece of documentation I had, including 3 photographs Dale had taken of the property on different dates during my absence showing the lawn mowed, the property maintained, and no reasonable evidence of abandonment. Robert Chen looked at the documents for about 20 minutes. Then he leaned back in his chair, and he smiled. Not an amused smile, a professional smile. The smile of a man who has just seen something he recognizes very well. He said, "Are you familiar with the Service Member Civil Relief Act?" I said I had heard of it but did not know the details. He said, "Let me explain. The Service Member Civil Relief Act, the SCRA, is a federal law, not a state law, not a local ordinance. A federal law that was specifically designed to protect active duty military members from financial and legal actions taken against them while they are deployed and unable to defend themselves. Under the SCRA, creditors and associations are severely limited in the actions they can take against a service member's property without following specific legal procedures. Fines can be disputed. Liens have specific challenge rights. And most critically, actions taken without proper attempt to notify a deployed service member can be challenged and reversed. But the SCRA was only part of what Robert had found. Because Texas, the state where my house sat, had its own additional layer of protection for military homeowners. The Texas Property Code had specific provisions addressing HOA enforcement actions against deployed service members. Provisions that the HOA was almost certainly not aware of. Provisions that Linda, with her clipboard and her violation notices, had walked directly into with both feet. Robert pulled up the HOA's own governing documents on his laptop. He read them for another 10 minutes. Then he looked at me. "Did they ever attempt to contact you directly before issuing notices?" I said no. "Not once," he said. "Their own CC and RS required direct homeowner notification before escalating to formal violation notices. They skipped that step entirely on every single citation." He set the document down. "Marcus," he said, "this lien is not just challengeable. It may be entirely void. And depending on how we approach this, the HOA may end up owing you money." I sat with that for a moment. $6,400 in fine for a house that was maintained, imposed without proper notification, against a deployed service member, in violation of their own governing documents, and potentially in violation of both federal and state law. I said, "What do we do first?" Robert said, "First we send a letter. A very specific, very carefully worded letter. And we send it to every member of the HOA board individually, by certified mail, so every single one of them signs for it personally and cannot later claim they did not know." That letter went out 10 days later. It was 4 pages long. Page 1. My deployment orders, confirming I was on active duty overseas during the entire period of violations were issued. Page 2. the specific SCRA provisions that applied to my situation, cited with full legal references. Page 3, the Texas Property Code protections for military homeowners. Page 4, a formal demand for the immediate removal of the lien, the full dismissal of all fines and penalties, and a written apology from the HOA board, or we would be filing in federal court within 30 days. Every board member signed for their copy. Linda signed for Hayes on a Tuesday morning at 9:47 a.m. I have the receipt. Robert told me to expect either a panic phone call from their attorney or complete silence while they figured out how bad their situation was. We got both. Their attorney called Robert the next afternoon. The tone, Robert told me later, was notably different from the aggressive HOA board communications I had been receiving. This was a lawyer who had just read the letter and understood immediately what it meant. He said they needed time to review the situation internally. Robert said they had 30 days, not a day more. And somewhere across that cul-de-sac, Linda was about to have a very uncomfortable conversation with the board she had led straight into a federal legal exposure. Robert had sent the letter. Every board member had signed for it personally. Their attorney had called in a mild panic. And now we were in the 30-day window waiting to see how the HOA was going to respond to the reality of what they had done. I want to tell you about what happened inside that HOA board during those 30 days, because I did not find out about it immediately. I found out about it later, from two board members who reached out to me directly, independently, and who were clearly not comfortable with how events had unfolded. Their names were Patricia and Dave. Both had been on the board for 3 years before Linda arrived. Both described themselves, separately and using almost identical words, as having been steamrolled by Linda's energy and confidence from the moment she joined. Patricia called me first, about 2 weeks into the 30-day window. She said she wanted me to know that she had voted against the lien, that she had raised concerns about whether the homeowner had been properly notified, that Linda had assured the board, assured them specifically, that multiple attempts had been made to contact the owner and all had gone unanswered. That was not true. There had been no attempts to contact me. Not by phone. Not by email. Not by any method. The number and email on file in the HOA system were both correct and functional. I had received other HOA communications on that email before my deployment. Linda had simply chosen not to use them. Patricia said she had not known I was deployed until Dale told her personally, which he had done. She said, about a week after the lien was approved. She said she had confronted Linda about it at the next board meeting, and Linda had said, and Patricia quoted this directly, the condition of the property is the issue, not where the owner happens to be. Dave called me 2 days after Patricia. He told me that an emergency board meeting had been called after Robert's letter arrived. He said the HOA's attorney had attended and had been extremely direct with the board about their legal exposure. He said the phrase significant liability had been used multiple times. He said Linda had spent most of the meeting arguing that they had followed proper procedures and that the SCRA did not apply in this situation. The attorney had corrected her on that point firmly and, by Dave's account, somewhat publicly. Dave said the meeting had ended with the board agreeing to consult further with their attorney before responding to Robert's letter. But he wanted me to know, he said, that the majority of the board was deeply uncomfortable with how this had happened and wanted to find a way to make it right. I thanked both of them for calling, and I passed everything they told me to Robert, because here is something important that I want to explain. Those phone calls from Patricia and Dave were not just neighborly gestures. In the context of a legal dispute, they were significant. They established, with named, willing witnesses who were themselves HOA board members, that the board had been given inaccurate information about notification attempts, that a board member had been informed of my deployment status and had withheld that information from decision-making, that the lien had been approved based at least partly on a misleading account of the facts. Robert used the word willful when I described what they had told him. That word matters in a legal context. The difference between an honest mistake and a willful misrepresentation is not just moral. It is financial. It affects what remedies are available. It affects what a court will consider when determining damages. Robert updated the legal file. He made notes of both conversations, their dates and times, and what had been shared. He asked me if Patricia and Dave would be willing to put their accounts in writing if it came to that. Both said yes. Meanwhile, the 30-day clock was running. On day 24, Robert received a call from the HOA attorney. They were prepared to negotiate. The attorney acknowledged, carefully, with a measured language of someone trying not to create additional legal exposure, that there had been procedural irregularities in how the violation process had been handled. He said the board were prepared to consider removing the lien and dismissing the fines in exchange for a mutual release of claims. Robert asked for that in writing. It arrived the next day. I read it that evening at my kitchen table. The offer was to remove the lien, dismiss all fines, and issue a formal letter of apology from the HOA board. In exchange, I would sign a release agreeing not to pursue further legal action against the HOA as an organization. Robert and I talked about it for an hour. He told me it was a reasonable offer as far as HOA settlements go. He also told me that if I wanted to push further, if I wanted to pursue damages, if I wanted to name Linda individually, if I wanted to take this to federal court and let a judge look at the full record, I had a case that was stronger than most he had seen. He said it was my decision. I thought about it overnight, and in the morning I told Robert, I do not want a settlement. Not yet. I want one more thing added to that offer before I sign anything. Robert asked what. I said, I want a full board review of the violation process for any property owned by an active duty service member or veteran. Written policy changes. Documented. Adopted officially. So this cannot happen to the next person who deploys out of this neighborhood. Robert was quiet for a moment. When we left off, I had told Robert the first wanted one more thing before signing any settlement. A full written policy chain protecting deployed service members from this kind of HOA enforcement action. Official. Documented. Permanent. Robert had said he thought we could get it. What I did not expect was how quickly. The HOA attorney called Robert back within 48 hours of our counter request. He said the board had discussed it and agreed. They would adopt a formal written policy to be presented, voted on, and recorded in the official board minutes, requiring any HOA enforcement action against the property to include a mandatory check of the homeowner's active military status before issuing violations. Any homeowner confirmed as actively deployed would receive a 90-day automatic grace period with direct written notification to their designated contact before any formal action could begin. It was not just what I had asked for. It was better. Robert told me the attorney had seemed genuinely relieved to add this piece to the settlement. He said it gave the board something they could point to, a positive outcome, a real policy improvement, rather than just a quiet capitulation. I did not care what it gave them. I cared that it was going into the official record, because the next person who deploys from that neighborhood, or the one after that, or the one after that, is not going to come home to 11 violation notices and a lien on their house. The policy will be there, written down, official, voted on and recorded. That mattered to me more than any money. The final settlement agreement was signed 3 weeks later. Every item confirmed in writing. The lien removed. Completely. Expunged from the public record as if it had never existed. All fines and penalties dismissed in full. $6,400. Gone. A formal written apology from the HOA board signed by every sitting member. The new service member protection policy, adopted officially at a board meeting, recorded in the minutes, incorporated into the HOA's governing documents. And one more item that Robert had quietly added during the final round of negotiations, a provision requiring the HOA to cover my legal fees in full. I signed the agreement on a Thursday afternoon. Robert shook my hand across his desk. I walked out to my car in the parking lot, and I sat there for a moment in the quiet. 6 months ago, I had come home from deployment to a stack of notices on my door. Now I had a clean title, a full apology, a policy change, and my legal fees paid. Not bad for a house with slightly overgrown grass. Now, I know what you are waiting for. What happened to Linda? I want to be careful here because this is a part of the story where it would be very easy to be unfair. Linda is a private citizen. Whatever mistake she made, and she made serious ones, I am not going to tell you her last name or point a camera at her house. But I will tell you what happened. The settlement agreement covered the HOA as an organization. It did not cover individual board members acting outside their authority. Robert had been very deliberate about that distinction in the final language. Linda, based on the accounts of Patricia and Dave, had made representations to the board that were factually false. She had been directly informed that the homeowner was deployed overseas and had withheld that information from the board's decision-making process. She had told the board that notification attempts had been made when they had not been made. Robert sent Linda a separate letter. Personal, not from the HOA, from my legal team, addressed to her individually. The letter outlined what we knew, what we could prove, and what our options were if we chose to pursue an individual action against her for her role in the series of events. It also made clear, and this was deliberate, that we were not necessarily planning to pursue that action, but that we were preserving the right to do so. I am told Linda resigned from the HOA board within 2 weeks of receiving that letter. I did not ask for that. I did not request it. I had no communication with Linda at any point in this process, and have not spoken to her since. But I will be honest with you. When Patricia texted me to let me know, a simple 3-word message, she stepped down. I read it sitting on my back porch with a cup of coffee, and I felt something I can only describe as quiet satisfaction. Not cruelty, not triumph, just the feeling of a thing being right, of actions having consequences, of a person who had used a position of community authority to harm someone who was serving overseas, and then face, in a real and tangible way, the weight of what they had done. I finished my coffee. I went inside. I looked around my house, clean title, no lien, mine, and I thought about the people I had served with overseas, about the ones who were still there right now, about the ones who would come home after long deployments to whatever was waiting for them. Some of them would come home to families, some to empty apartments, some to stacks of mail and overdue bills and 100 small practical problems that had piled up while they were doing something that most people back home would never fully understand. I hoped they would not come home to what I came home to. And because of one written policy change in one small HOA in one suburb outside San Antonio, at least some of them would not. You have heard the full story now. HOA placed a $6,000 lien on my house while I was deployed overseas. I came home, hired the right lawyer, discovered federal and state protections I did not know I had, and walked away with a lien removed, all fines dismissed, my legal fees paid, a written apology, and a policy change that will protect future service members in my neighborhood. But this video is not just for military families, because the lessons inside this story apply to every single homeowner who has ever dealt with an HOA, a neighbor dispute, or any situation where someone in a position of authority decided the rules applied to you differently than they applied to everyone else. So let me give you 6 lessons. Every one of them owned. Lesson 1. Know the laws that protect you before you need them. I did not know the full scope of the Service Members Civil Relief Act before I sat down with Robert. I had heard of it. I did not know it applied to HOA liens. I did not know Texas had additional state-level protections layered on top of it. Most people find out what protections exist only after someone has already violated them. Do not be that person. If you own a home, spend 2 hours understanding your basic legal protections as a property owner. What the SCRA covers if you or anyone in your household serves in the military. What your state's HOA laws actually say. What your HOA's own CC and RS require before they can take enforcement action against you. That knowledge costs nothing but time, and it can be worth thousands of dollars when you actually need it. Lesson TWO. Your HOA's own governing documents are your first weapon. Linda never thought about the CC and RS she was supposedly enforcing. The HOA's own rules required direct homeowner notification before formal violation notices could be issued. That step was skipped on every single citation. Every single one. Before you push back on any HOA action taken against you, read the governing documents, the CC and IS, the bylaws, the enforcement policy. Read them carefully and look for the procedures they are required to follow. 9 times out of 10, when an HOA oversteps, they have also skipped one of their own required steps. That skipped step is your leverage. Lesson 3. Get a specialist, not a generalist. I could have called any attorney. I called Robert Chen specifically because he specialized in military law and housing rights. That specialization meant he knew immediately what protections applied, how to invoke them, and what language to use to make the other side understand instantly how exposed they were. A general practice attorney might have gotten me to the same place eventually, but eventually costs time and money. A specialist gets there faster and with more force. Whatever your dispute, find someone who has handled exactly this kind of case before. Not someone who does a little of everything. Someone who knows a specific area of law the way Robert knew it. Lesson 4. Documentation from other people is just as powerful as your own. Dale's photograph of the maintained property. Patricia's phone call describing what Linda had told the board. Dave's account of the emergency meeting. None of that was documentation I created myself. All of it was critical. When a dispute begins, talk to people, not to vent, to gather information. Who saw what? Who knows what? Who was in the room when decisions were made? Who has photographs or messages or records? The people around a situation often hold the evidence that decides it. Patricia and Dave did not want to be witnesses in a lawsuit, but they both said yes when I asked if they would put their accounts in writing if it came to that, because they knew what had happened was wrong, and they wanted it on the record. People often want to help when asked directly and respectfully. Ask. Lesson 5. Think about the next person, not just yourself. The policy change was my idea, and I fought for it specifically because I was thinking about the service member who would deploy from that neighborhood 2 years from now and come home to the same stack of notices I came home to. I could have taken the original settlement offer. Lien removed, fines dismissed, apology letter, done. Easier and faster. But easier and faster would not have helped the next person. When you are in a position to create a structural change, a policy, a written procedure, a documented rule that prevents the same harm from happening to someone else, push for it. It costs you very little when you already have leverage. And it matters enormously to the person who comes after you. Lesson 6. Calm is the most powerful thing in the room. I was furious when I read that lien letter. Genuinely, deeply furious. 14 months overseas, and this was what was waiting for me. But I did not call the HOA that night. I did not go knock on Linda's door. I did not post about it publicly while my emotions were running hot. I slept. I ate a real meal. And in the morning I called a lawyer. Every good outcome in this story happened because I stayed calm long enough to be strategic. Anger tells you to react. Strategy tells you to respond. Those are very different things. React and you give the other side something to work with. Respond, carefully, documented, legally, and you give them something they cannot handle. It has been about 2 years since I signed that settlement agreement. 2 years since the lien was removed and the fines were dismissed and Linda stepped down from the HOA board. A lot has changed. Some things have not changed at all. Let me tell you about both. The house looks great. I will say that first because it matters to me. I spent the summer after I got back doing all the deferred maintenance myself. The trim that needed painting. The driveway crack that needed sealing. The flower bed that needed real attention. Not because the HOA told me to. Because it is my house and I take pride in it. The lawn is never more than 3 inches. Not because I am afraid of another violation notice. Because I genuinely enjoy mowing it on a Saturday morning with a cup of coffee on the porch afterward. It is one of those small rituals of home ownership that apartment living never gave me. Dale is still 2 doors down. Still retired. Still the best neighbor on this street by a significant margin. I brought him a case of his preferred beer the week after the settlement was finalized. He waved it off and said he was just glad I was home safe. I left the case on his porch anyway. Patricia is still on the HOA board. Dave stepped down last year. He said 3 years was enough, but Patricia stayed. She told me she stayed specifically because she wanted to make sure the new service member protection policy was actually implemented correctly and not allowed to quietly fade into the governing document without anyone enforcing it. She takes that seriously. She has already applied it once. A homeowner on the next street over, a Navy Reserve member who was called up unexpectedly for a 6-month deployment. Patricia flagged his file herself before any violations could be issued. She set up the 90-day grace period. She made sure his designated contact received the proper written notification. He came home to a clean driveway and no stack of papers on his door. That is the part of this story I am most proud of. Not the money, not the legal victory. The new HOA board is different. Not perfect. No HOA board is perfect. I have made my peace with that, but genuinely different in tone and approach. Less clipboard, more communication. The current board president sent out a letter last spring reminding all homeowners about the violation process and encouraging people to reach out directly before things escalated to formal notices. Small thing, but it says something about the culture. Linda no longer lives in the neighborhood. I found out from Patricia that she sold her house about 8 months after resigning from the board. I do not know where she went. I genuinely wish her nothing. Not good things, not bad things, just nothing. The most complete form of indifference I can offer someone who caused me real harm and has now simply exited my life. I want to take a moment here and speak to something directly, because I have told this story to a few people in my personal life, and I have gotten two different reactions. Some people hear the outcome, lien removed, fines dismissed, apology letter, policy change, legal fees covered, and they say good, that is exactly what should have happened, justice was served. Other people hear it and they say, was it worth it? The stress, the legal process, the months of uncertainty? Would it not have been easier to just pay the fines and move on? I understand that reaction, and I want to answer it honestly. No, it would not have been easier, not because paying was financially impossible. I could have scraped together the money eventually, but because paying those fines would have meant accepting that what happened to me was acceptable, that a volunteer board member could misrepresent facts, withhold critical information from her colleagues, and impose financial penalties on a deployed soldier, and face no real consequence. That the system works that way and you just have to live with it. I was not willing to accept that. Not for myself, and not for the next person. There are times when the right thing to do is also the hard thing to do. When letting something go costs more than it saves. When the precedent you set by walking away is more damaging than the fight in front of you. This was one of those times. If you are a service member watching this, or if someone you love is serving right now, I want you to know about the SEIA. I want you to know that federal law was written specifically to protect you from exactly what happened to me. I want you to know that you have rights as a homeowner that do not pause when you deploy. And I want you to know that there are attorneys who specialize in exactly this, who know those laws cold, who have fought these cases before, and who can help you. You served. The law is supposed to serve you back. Make sure it does. And if you are not military, if you are just a homeowner dealing with an HOA that has decided the rules apply to you differently, I want you to know that the governing documents they enforce are the same documents that govern them. Read them, know them, and do not sign anything or pay anything until you talk to someone who knows property law in your state. Your home is yours. Nobody gets to take pieces of it, even in fine form, even through a lien, without following every required step of every required process. And when they skip those steps, when they cut those corners, when they assume you do not know your rights well enough to push back. Push back. Stay organized. Stay calm. Find the right help. Let the process work. That is all I did. And I came home from deployment to a house that is mine, completely, cleanly, legally, undeniably mine, and a policy that will protect the next soldier, sailor, airman, or Marine who comes home to this street. That is the whole story. Thank you for watching all 6 parts. If this connected with you, please subscribe and share this with anyone you know who is serving, who has served, or who is dealing with an HOA situation that does not feel right. Leave a comment. Tell me your story. I read everyone. I will see you in the next one.